Rape and Related Offenses, Lecture 13. PC 261, rape, the act of sexual intercourse accomplished with the person, not the spouse of the perpetrator, so a husband or a wife couldn't be responsible for rape, and any of the following conditions apply. The sex act has to occur under any of the following circumstances. So if you have multiple violations, in other words, more than one of these apply, you have more than one crime. They include the victim being unable to give consent because of a physical or mental condition. Now, this is only applicable if we can show the suspect knew of this condition. In other words, a person is mentally disabled and they really don't understand what sex is, they don't understand what consent is, and the suspect takes advantage of this situation. Or the suspect knows that the victim is physically disabled, like they're paraplegic or what have you, and they take advantage of the situation. So that's one example. The second circumstance could be where it's accomplished against the victim's will. This is the most common one, and it's usually by force or violence, duress, menace, or fear of immediate injury to the victim or to another. The sex act could be perpetrated without consent if it's accomplished by threats, and those could be of great bodily harm, and they must be accompanied by apparent power of execution, that the person's scared that the person could actually do this. Next situation is where the victim is rendered unable to resist due to an intoxicating narcotic or an anesthetic substance, and it could be administered with or without the knowledge by the accused. The next circumstance is the victim is unconscious of the nature of the act, and this is known to the accused. In other words, they're passed out or asleep. Next, the victim is tricked into believing the suspect is their spouse. Next, the act is committed against the victim's will via threats of harm to the victim or to another person, and these could be future threats of something could happen in the future, or that the act is accomplished by threats to use authority of a public official to incarcerate, arrest, or deport the victim or another, and the victim has reasonable belief that the suspect is a public official and has this power. Sexual offense definitions. Definition of sexual conduct, or the basic law, basically law says that sexual conduct is permissive. That meaning that there's no sex act in California other than incest or bestiality that's illegal. So therefore, as long as you do it at home in the privacy of your own bedroom, and that you are giving permission or consent to do this, then it's okay. All California law is statutory, so it's got to be written down. And I just gave you the two sections that come of mind as that would be considered illegal. Penetration. When they talk about penetration, what's a sex act? What's sexual intercourse? Well, penetration is defined under 263 PC. You need to look that up. It says that any penetration, however slight, is sufficient to complete the crime. So we could use circumstantial or direct evidence to prove this. They could include medical examination of the victim, or forensic evidence including semen samples in the victim or vaginal fluid on the suspect. Means of force. Definition of force is unlawful touching of the body of a person, similar to a battery. Duress. It could be direct or implied threats of force, violence, or retribution. Basically, scaring the person into doing something that they normally wouldn't do. Menace, when you think about a menace, again, it's where the person is put in fear of injury. In regards to 261, 286, 288A, and 289 PC, these are all situations where if there's a positive cooperation in act or attitude involving the use of free will, this is the definition of consent. And if you want to break it down further, the victim must not only act freely and voluntarily, but they, number one, must know the nature of the act. So they have to be old enough, over 18, and mentally have the capacity to understand that. They have the capacity to give permission, meaning that they're conscious, that they're not intoxicated. And current or previous dating relationships are not sufficient to show consent. So if we talk about capacity, you want to check on whether a person has given consent. The first thing you got to see is how old are they and their mental condition, and did they have the capacity to give consent? And then second, did they do it? Was it of their free will? Mistaken belief rule on consent. In 1992, there was a defense brought up by California Supreme Court that said if there's substantial evidence of equivocal conduct, meaning that the suspect can show that the victim did something that would cause a normal, reasonable person to believe that consent was given, that could be used as a defense. On the other hand, if the victim is prevented from resistance by threats or drugs, it's very typical now that people are using various drugs and administering them to victims, and they lose consciousness, they have sex with them, they wake up in a hotel room. That would be an example of administering drugs. Or they make threats. Had a case in Berkeley where the suspect threatened to kill the victim's 3-year-old child. She said, look, I'll have sex with you, but you need to use a condom, and I have the condom. She gives him the condom. He uses it. She doesn't resist. He later claims in the defense that she had consensual sex with him, which is totally outrageous. Threats can also be made through nonverbal communication, like the suspect shows the victim a knife. Victim is unconscious of the nature of the act. In Regina versus Flattery, the doctor penetrates the vagina of the victim while she's unconscious from a surgical operation. In Moran versus Michigan, consent obtained by fraud, the doctor convinces a patient that sexual intercourse is part of the needed medical treatment. Yes, believe it, this actually happened in 1972. It's also 266 PC where the victim believes that this perpetrator was her spouse. So the husband's away, intruder enters the house, climbs into bed, victim thinks it's a husband, allows sex, and then finds out it's not. In People versus McCoy, the suspect went as far as to put on a fake wedding to entice the victim into having sex. She thought they were married and that he was her spouse. And again, threats to use authority against the victim, threats to deport illegal female aliens are used to force them to have sex. The following sections listed I want you to review yourself. They include 261.5, statutory rape. You need to explain the difference between misdemeanor and felony application of this. 262, spousal rape. I need you to make sure that you understand the statute of limitations. Look at 286, sodomy, 288, child molestation, 288A, oral copulation, 289, anal or genital penetration with a foreign object. 285, incest. I spoke about incest earlier. I want you to look up section 59 of the California Civil Code and give me the rundown as to what relations are not allowed to have sex in California. Can first cousins have sex? I'd like to know that also. Under PC 314, indecent exposure, I want to know what the difference is in the elements for a felony application of this versus misdemeanor. What's the difference between the felony and misdemeanor sections of this? 647.6, annoying children. PC 11-4-14, harassing an employee's child. 653G, loitering around a child's restroom. And 290, sex registrant. I want you to tell me, be able to explain for testing purposes, how long a registrant has to register with the police department after their birthday, and how long they have after they change residential addresses to register themselves.